And we are ahead of schedule, which is good. We're moving into the Legal Advisory Committee discussion topics. And they are going to be taken out of order and again based on priority. So we're moving down to item 3A, which is a discussion of the Gibson, Dunn, and Crutcher Section 5 memo and the decisions we may need to make on instructing Q2. So this is what I was alluding to earlier and was the purpose of having Mr. Brown come in as well, which is that we need to make a decision on how we're going to instruct our line drawers based on the advice of counsel. And so what we'd like to do today, and we also have it confirmed with Q2, and Bonnie has made arrangements with Christian to get audio files, and we do have a transcript running. So although Kyle, our typical note taker, is not here today, we feel comfortable that Q2 is aware we will be providing specific directions if we can reach a decision regarding these areas. And therefore, they will be obtaining the transcript and audio of this meeting so we can feel free to make decisions and instruct Q2 in that regard. So in the manner in which we'd like to proceed, it does make it a little bit more difficult because we do not have mappers here and we don't have the customary maps ahead of us, but we do have access to them online, as does the public. So that's how we're going to proceed with discussions based on the advice of counsel that we've received today. So we'll just go in order of the manner in which Gibson, Dunn, and Crutcher had put that together on their worksheet, their spreadsheet. And so we'll take it first by Assembly District and then Senate District and Congressional and move forward for each one. So the first one on theirs, I believe, is Kings. Yes, Commissioner Malloy.
In looking at our website, I don't actually see this document posted to the website yet. Is that going to be available for the public today? Maybe I could just... We're talking about the work plan, not the work plan, the
It's a CRC
list.
spreadsheet from Gibson Dunn. I may have failed in advising staff to put it up, but essentially it's everything. It's what they've highlighted as being retrogressive. So it's everything that pretty much Mr. Brown had spoken about before. If they can put it up today, I can ask. Okay.
I'll email it right now.
Thank you. No. Okay, so in looking at Kings County, Commissioner Dye, did you say that you had some of the benchmark numbers? Oh, sorry.
Can I believe that was labeled as work product, so I'm not comfortable necessarily with that posting. I'd like to confirm that because I believe it was listed as confidential attorney work product. I believe. I don't have it right in front of me right now.
Okay, we'll take a look at that. So hold on that, staff, but it doesn't change what we need to get done too as well. So we'll take a look at that. So who'd you send it to, Connie? Janice or?
I sent it to Janice and to Ms. Shoup, but I'll send a follow-up email letting them know to hold off.
Okay, thank you. Sure. As the public may or may not be aware, we have retained attorneys, and under those circumstances, they perform their own work, and in doing so, they render their own opinions and come to certain conclusions. Under those circumstances, their work is protected by what's considered a work product privilege. And under those circumstances, their work is protected unless during litigation it may be compelled to be produced. At this time, we'll look into it further, whether the essential work or spreadsheet that they have provided to us is covered by the work product privilege, and we'll confirm that. If not, we will proceed with our customary practice of transparency and provide that. But in the meantime, again, most of what we've been discussing on Section 5 that we heard from Mr. Brown about will aid us in our decisions and determinations of each of these districts that we would like to make decisions on for Section 5 purposes. Beginning with Kings County. Does anyone have the benchmark? I can pull it up now. We wanted to just get through it. I thought they were on the maps, but it doesn't appear that they are. It's my understanding that I believe we reached the benchmark as to the Latino VAP, and there's a 1.5% drop in Asian VAP and the Black VAP. So based on the advice of counsel, we have, and those are the lower numbers. So based on the advice of counsel, oh, excuse me, let me back up. Talking about the Assembly District. Based on the Assembly District, there does not appear to be any retrogression in Kings County for the Assembly. For any of the groups. So the decision that the Commission would need to make is that we would basically not be making any changes to the Assembly District for Kings County at that level. I don't know that we need to move forward with a vote or not, but Commissioner Dye.
Yeah, I have a suggestion. As I recall, there were only kind of 2 districts that, based on advice of counsel, that we probably really need to think about. One is the Merced District, and to discuss the Stockton Finger issue, and the other one was one of the Monterey districts, which actually retrogressed Latino CVAP.
And you're correct that does require additional discussion. What my thought was, and I'm certainly open to anybody else's suggestions in this regard, as we understand it, these areas are affecting any other district that's drawn around it. So if we have a consensus that we're not going to change any of them, that's why I wanted to run through them by county. And so if we could go through them quickly, at least and have a confirmation that the Commission understands that there wouldn't be any changes to those, that certainly there would be no need for discussion, but then we're not changing those districts if we are satisfied with the manner in which they are drawn presently. Because they're meeting, they're not retrogressive, they meet the benchmark, let's say, for the Assembly District in Kings. So I'm taking it step by step only because we will get into a healthy discussion of the others, but then if we could have confirmation on that, we don't need to come back to that issue later on. Whether it requires a vote that we're confirming, agreeing that we're accepting it, I'll just move on if we don't feel that a vote's necessary for those individually. Okay. Then moving on as far as... Actually, no, I'm still in Kings, just real quick. I'm just going down. Yeah, right. So as to the Assembly District in Kings, we already said that we've met the benchmark as to all of them, so that looks good per our council. The Senate District for Kings County appears to be 1% drop in the Asian VAP, and appears to be non-retrogressive, except for that 1%, and that's what he was talking about earlier.
Question of clarification.
Sure.
Who made the comments? Is it Q2 or is it
Gibson
Mr. Brown?
Gibson done.
So what's the definition of appear to be?
Because of the 1% drop, the difference between the 1% and the benchmark. So the Asian benchmark is 5.61%. For Asian VAP, the proposed district is 4.75%. The Asian CVAP for the benchmark is 5.19%. The proposed is a little higher at 6.53. So this is where he had given us advice that we may need to go back to Q2 for additional information on the Asian CVAP for Kings County.
Chair Wilkins-Weber. So under the column responsibility, where it lists Q2 and GDC, are they going to follow up on these questions?
If we're providing instructions today to Q2 for these districts, so given the difference between the CVAP and the VAP for Asians for Kings County under the Senate, the instruction would be that Q2 would need to provide us additional information pursuant to Gibson Dunn's recommendation that the commission instruct them
Okay.
on the difference between the two. Because if they can clarify that issue, because we're just looking at Asian VAP, if they can provide us confirmation on their proposed CVAP for Asian, which is 6.53, then we probably wouldn't have any be retrogressive right now.
Yes.
On the Senate districts.
I see.
So the instruction, essentially based on advice of counsel, is to instruct Q2 to provide additional information on the CVAP and to probably search their database and the census information that we had talked about before to see if they could prevent the retrogression.
All right. It has a start date and a due date. Do we need to give them deadlines?
Correct, but
I'm sorry, can we?
That's where the drop is at. So that's why he was saying we needed to confirm the accuracy of the CVAP. But
So my question would be, I think I heard Mr. Brown to say, and maybe folks, we should decide on this, that he felt it was sufficient to look at VAP for the retrogression issues on these smaller populations. So let's make sure we're all looking at the same thing, that the VAP, or
this is what he said earlier today. He said that you do not have to use CVAP for Section 5. You use VAP as the benchmark. And based on the information that we have here, that's where the 1% is at.
Right.
So if you're looking at the benchmark numbers, again, just going off of, so the instruction to Q2 would be not to be retrogressive. Advise us where you can obtain additional Asian population or API population for Kings County at the Senate district level. And if you cannot find the additional population to meet the benchmark, then to provide us a written explanation regarding why you cannot reach the benchmark for Kings County in the Senate district.
Chair Wilkins-Weber.
Yes.
So going back to the columns where it says start date and due date, do we instruct them to with some dates, or is this part of the work plan? I'm not sure.
This is part of the work plan. So this is where Angela and I will be really coordinating between these two groups in order to make sure that these questions are answered or resolved. So what is important is the process we're going through right now is identifying what issues, because on that task list there's a multitude of things going on. We need to really focus on those things that need to be answered for us, and we're doing a great job. I'd like to continue that, and then know that the timeline will be incorporated by the work plan.
Great,
That's okay.
Thank you very much.
Okay, sorry I confused you earlier about the CVAP and VAP. I confused the discussion earlier. But so if the commission agrees, that would be the instruction to Q2 for the Senate district for Kings County. Okay, no objections? Terrific. Moving on. The congressional district for Kings County. It appears that there is a 1.5% drop in the Asian VAP and the black VAP, and appears to be non-retrogressive. The benchmark for the black VAP is 6.95%. The proposed district is 5.39%. The benchmark for the Asian VAP is 5.41%, and the proposed is 3.99%. So again, based on the advice of counsel, the recommendation would be to instruct Q2 to find additional population so as to make this congressional district for Kings County not retrogressive, and to the extent that they are unable to, for the Asian VAP and the black VAP, to provide us a written explanation regarding why they are unable to do so. So agreed? Okay. Moving on to Merced, Assembly District. According to our counsel,
Chair
this looks like
Wilkins
there's a
Weber.
drop anywhere, but he doesn't even. Oh, that one's above. Okay, yes, Commissioner Yao.
The deviation number, it's also likely to change, and shall we consider that before trying to work the percentage on the retrogression? In other words, you were satisfied with the deviation in the case of the Kings County. Is that what we have decided? Because you get yourself caught in a situation if you resolve the retrogression and then you have to add or delete the population from it, you may end up having to redo it. So we probably need to get direction associated with each of these Section 5 districts.
You mean on population deviation?
Right.
Well, I mean, we already have instruction to them regarding population deviation. My only, I wouldn't be concerned about that at this point because I want them to tell me where they may have a problem with population deviation. The difficulty in doing this without having mappers here is because of we wouldn't be able to discern that at this
I'm
point.
just concerned about the interaction between the population deviation and
Commissioner
the
Dye.
retrogression data.
So, we'll take a 5-minute break. Or we could consider lunch.
That's
It's noon.
Consider lunch.
Take a break. Let's get through Merced. Okay, thank you. We'll get through Merced. Commissioner Dye?
Yeah, I think what Commissioner Yao is trying to say is that if the population deviation changes, it will necessarily change all of the percentages. So we have to decide whether we're going to stick with that deviation. For example, this deviation for Kings is extremely low. If we wanted to, allow for the flexibility that the law provides, it would also change the numbers. It would change the benchmark. It would change the proposed district as well. So I think the question is a really good one, which is, are we going to assume that we hold population deviation where it is now? Do we want to give Q2 the flexibility to play with the population deviation a bit because it might change our retrogression numbers?
Any other thoughts? Commissioner DiGiulio.
This issue of deviation, again, was going to come up a little bit later because part of the issue is, as we understand it and looking back at our motions, is we had a motion for the allowable deviation for our first draft map. I believe it was just mentioned in first draft, and then we have a deviation set right now for our final, but those are significantly different and a tighter deviation. So we may want, I think it's worth us having a discussion if we want to continue with that tight deviation. It will mean that in our second draft maps there will be significantly more cuts to cities and other things because we have some of those deviations that are larger now than what we've set for our final maps. So if we would like to, we'd have to understand that if we're staying with that deviation, it's going to result in more splits. Or if we'd like to a lot more. Or if we'd like to revisit this issue and consider other direction, because really the deviation set for the final maps is that which is going to be set for the second draft maps. So again, we look at what's happened right now and understand the implications of our current deviation, which is a very tight one. So I'm not sure what the chair would like to do with that discussion at this point.
Well, before we can make any decisions and moving on further direction, the commission should make a decision whether we would have them stick to the deviation or in our instructions strive for the decisions that we made on deviation for the second draft map. Because our idea is that whatever the iteration they come up with, or we leave it as a working iteration that they come back to us for. Commissioner Bravo.
As I recall your initial direction, you said make the change or come back and tell us why you can't. And it seems to me that if they make the change and they get the deviation over what we requested, they should come back and tell us, and then we can make a judgment at that point. But it's kind of hard to say that in lieu of knowing what the consequences are.
Commissioner Dye and Commissioner Blanco.
Well, so again, to use a very concrete example, for Kings, I believe the deviation is 0.253%, and even by our tight standards, it could be 1. So my question is, do we want to give Q2 the latitude to use that population deviation because it will change our retrogression numbers? It may help improve them. It may not, but the point is it could help improve them.
Commissioner Blanco.
Yeah, that's what I was going to recommend, is that since we already said here, we know what our deviation is for the next and final maps, the 2% total deviation. I think we could give an instruction over on all of these districts, even not the Section 5, just all the changes that we're going to be instructing them to make, that they have the ability to go up to a total of 2% if necessary. But, that if they can keep the percentage, if they have a percentage that's lower than 2% and they can keep it, they should try and keep it. But I do agree that if we don't give that instruction now, that they can do that, the constitutional mandate of 2 total, then they might be not able to do what we're asking them to do throughout these maps. So I would agree concretely right now on Kings I would agree that we can tell them that if going up to a total of 2 helps them minimize the retrogression, which is after all a significant issue with the Department of Justice, that we do so.
And just to clarify, Commissioner Blanco, what we have in our motion is not 2%; it's 1%.
Oh, 1.
Yeah. So they could only go up to 1%. And currently, these maps were drawn allowing them to go up to 5%. Yeah. So if you can imagine the amount of the difference between 5% and 1%, it's going to be very tight. So we did vote on that. Yeah. Yeah, we actually voted on that. Which technically we have the motion really only is 1% for the final maps as written. And the second motion was in response to the first draft. So there's nothing on the record for the second draft. But I would assume, maybe we shouldn't make this assumption, but the second draft map really is the iteration of the final draft map. Yes. So right now it would be, as written, it is 1% total.
That's what I recall, too.
Commissioner Duck.
Yeah, I just have a legal question. In the case where we determine we, in fact, have to draw certain Section 2 districts, but it requires a greater population deviation to do that, wouldn't that really put us at legal risk, since the Constitution actually gives us a much wider range of population deviation. I mean, we are choosing to impose this very tight population deviation, but from my understanding of the law, it's presumed to be reasonably equal for legislative districts if it's a total deviation of 10%. So I'm just wondering if we're putting ourselves in a difficult spot here because of the tight population deviation that we might end up running afoul of DOJ.
Well, you are talking about two different standards again. You know, you're talking about federal constitution standard, which is the ceiling. Then you've got the state standard, which is the floor. So if you'd like, I can pose that question to Mr. Brown as additional, unless Commissioner Anchetta can answer.
And I think we had this discussion, and we often revisit our earlier discussions. That's okay. But sometimes our memories fail. So for that discussion, and I was not in on the call where there was a discussion with Gibson Dunn regarding the source of law regarding the 1% deviation, right? So my recollection of that discussion, and again, those of you who are on the call should just relay this in the absence of the actual attorney who gave the advice. If it is a state constitutional mandate that it be 1%, then we should follow that, even though there may be some potential conflicts with federal law. If it's not a state constitutional mandate, as opposed to just sort of a guideline that has been adopted in previous by the Supreme Court of California in its line drawing capacity, not as a court litigating a case necessarily, that's different. And again, I think the commission is free to. We can go to zero if we want. And I actually think we would like to go to zero if we could. And all these things are sort of lined up. That'd be great. But I think there is this issue around whether it is required under the state constitution to do a 1% versus, as a policy matter, we would like to do 1%. And perhaps, if we want to, we didn't leave room for exceptions. Whether we want to allow some exceptions for particular deviations, including the Voting Rights Act in particular, but for others as well. Again, we will, of course, have more city and county splits. That's inevitable, given, as we know from the congressional districts, that's an inevitable consequence. But I think we need some clarity on whether it is, again, a state mandate versus a good state guideline that we ought to follow. Because if it's a guideline, I think we should think about whether we should just create an exception of some kind. If it's a state constitutional mandate, I think we have to decide how, because we have some tensions between getting sued in state court versus getting sued in federal court, which I think are hard to resolve.
Right. I think we should pose this in a more precise, pointed way to council. We have discussed it. If what I recall Mr. Kolke saying on this issue was that obviously the closer we got to zero, the better, particularly since the technology is there to be able to do that. But that if we had a consistent policy for when we deviated, that was the most important thing under the way that the law has been interpreted constitutionally in California, is to have a consistent policy for it not to be arbitrary or irrational. And so I think the point we should ask them point blank is, if we need to go beyond zero to meet Section 2, then is that something that they, in their legal, advice to us, think falls within the language of the Constitution that says, what's the phrase, where as practicable as possible? I think that's the question to pose to council from my perspective.
Commissioner DiGiulio.
And I don't know if this is, in addition to that question, I don't know if this is for our VRA attorneys or for our own legal counsel, but I'd also like to pose what's allowable if we have a consistent standard. because I was one of those when this vote came up that preferred to have a tighter standard, just to, let's just make it closer to zero as possible. But I'd like to know if there's a ruling. What does the law allow us in terms of, let's say, I'm looking at a lot of what we did already, and I recognize that if you say in assembly, about each 1% is about, what was that, about 10,000 people or so? It's about 10,000 people. So if we're at a 1% and you go up to, or excuse me, 4%, if you go up to 4 or 5%, and it's illegally allowable, you could actually reduce the amount of splits of cities if you're adding 20, 30, 20,000 more people in it. So to me, the trade-off, now looking at the implications, as Commissioner Baraba said earlier, is what are the implications of a tight deviation versus a higher one? And if the law allows us, I'd like to know what the ruling is to allow us to go up to the maximum amount, regardless of VRA issues. And that's where I'm not sure if it's the VRA attorney or our own legal counsel, or Commissioner Chetta, constitutional or our legal team. But no, I'm sorry, he's not.
I am not the commission's lawyer.
With his input. So, or legal. Actually, this is just for the legal advisory committee, maybe, because I'd like to know what the law allows, because I'd like to make it in consideration of the impacts it has for issues outside VRA, like splits. Because my ability to support a lower deviation waivers when it comes to the implications of that.
And unfortunately, what we've heard from our lawyer in reviewing my notes of that conversation is if you can develop a policy that is consistently applied throughout all of the districts. So I'm a little hesitant to say that we could actually have quote-unquote exceptions for Section 2 based on what Commissioner Dye and Commissioner Anchetta had said, because that wouldn't necessarily be consistently applied criteria for all districts if you allow greater population deviation just for a Section 2 purpose. Commissioner Dye.
Yeah, I actually disagree, because it's basically a consistent policy about applying the Voting Rights Act. And I was going to say it's not just for Section 2, it's for Section 5 as well, because this discussion came up when Commissioner Yao brought it up for Section 5, and he's absolutely right, because if the population deviation were greater, we may actually be able to increase the VAP for the smaller populations. I mean, it may not be enough to not totally retrogress, but it will be better. And if the question, as counsel posed, really, that would come up is, could we do better? And we show that we could do better if we increase the population deviation. Aren't we putting ourselves at risk? That was really my question, because we can do better, I suspect, in several of these counties. And the reason it's as bad as it is in certain of the districts is because the deviation is too tight. So I would say that the consistent policy is to look at, better compliance with the Voting Rights Act, and that obviously that would apply to the whole state for Section 2, and it would apply to the 4 counties for Section 5.
Any other thoughts on this issue? Commissioner Ontai?
And then the opposite would be a different standard for the non-Section 2 and Section 5 districts?
No, because the Voting Rights Act applies to the entire state of California and applies to the entire nation. So, it's just that certain districts may be required to be drawn under Section 2. That's what I'm saying. It's actually completely consistent. And just to follow up on Commissioner DiGiulio's point, we could have a consistently applied policy that says we are willing also to have a higher population deviation to minimize the number of city, county, community of interest, and neighborhood splits. And we can decide what that ceiling is. Maybe it's 2, maybe it's plus or minus 2, whatever that is. But the point is that I think one of the challenges of putting out a first draft that had relatively few of these splits is that now we're going to do a second draft and a final one that's going to have a lot of them. And so people who are relatively happy with the first draft may be really unhappy with the final. So it's just a thought.
Commissioner Rye.
Well, from our meeting in LA, I was always in favor of a higher deviation. And I think now that we've seen the consequences of having to be so tight, I would favor a policy for I don't want to say the rest of the state, but apart from Section 2, Section 5, if it's going to be a policy articulated differently, but still looking at what I understand our council's advice to be, which is to follow all the criteria in the Act. And so if we're not talking specifically about a Voting Rights Act issue, then we're moving on down the line, and the preservation of cities and counties and so on, all those geographic boundaries, I think is pretty important, and I think that's something we do need to look at.
And I would agree. I don't take Mr. Kolke's advice that it has to be for every district to mean that you can't have a consistent overall policy that you can deviate in order to comply with Section 5 and Section 2. I think that is a consistent policy that you're applying to all the districts. So I think I was just going to say, I think we have to make a decision here sooner or later. We could just be talking about this.
Commissioner Malloy.
I'm not sure what direction you're hoping to take the conversation, if you want to actually have a motion and some sort of action. I just wanted to express I'm also one of the people who was very concerned about deviation in the initial stages of the conversation, and felt like, based on my own understanding of the law and the feedback we were getting from the public at that time, that we wanted to have a very tight standard of deviation. I think that it has served its purpose, and that now both we as a commission and the members of the public have seen the unintended consequences of what that tight deviation has meant, both for VRA, for city splits, for county splits, et cetera. So I would really be interested and supportive of a policy that would be uniformly applied across the state, that would allow for more flexibility in reaching some of our other criteria.
Commissioner Brava.
I assume we're only talking about California legislative districts here. We're not. Okay, thank you.
Just the state districts. Commissioner Ward.
I'd just be interested in having this discussion with council, here, and having an engaged discussion with them regarding this, and defer it till then. Yeah.
Okay.
Could I think the follow up on Commissioner Ward said, maybe we could put this on the agenda for our next business meeting, and I think that we would have to make a decision about that, because that's the last one before we go into our line drawing, and we will have to have this decision finalized in order to be able to be effective in the directions that we give to them. So maybe we could have an opinion by our legal counsel and our VRA counsel as well, and have it on a discussion point for the next meeting. Can I propose that?
Got it.
In the meantime, though, Q2 is going to get audio of this direction that we're providing to them, and although I'm not a fortune teller, but I get the impression that what we might end up getting from our VRA counsel is that we need to strive to follow all of this criteria, which includes our tight population deviation. And if we can achieve that, their instructions to us is to make sure that there's no retrogression. So, and I'm thinking, what if we can do both? Mm-hmm. And so I'd really like to see, by adding population to Kings, for example, they still could stay within the population deviation that they're at and still be non-retrogressive, by taking out other groups. So I think that they might still be able to achieve that. And what we've seen consistently throughout, give or take a few districts, they really have been striving for less than 1%. So if they can achieve that, we may very well be in a situation where this entire discussion's been great, but maybe they can achieve it with the technology we have now. Commissioner Dye?
Yeah, just the one clarification. They also did advise us to try to improve where there was some retrogression for the smaller populations, that we should try to improve it as possible. So my only suggestion was that we give Q2 the latitude. We can discuss whether we want to have a greater latitude than the motion we previously passed, but to give them the latitude to go up to 1% if it improves those smaller populations.
Okay. Commissioner Yao.
I apologize. I didn't intend to bring this deviation into the discussion, but I just want to clarify the direction that we're giving to Q2, and I would support giving them the direction saying you can increase the deviation from what you presented on the draft map to up to the 1% limit that we have previously discussed. I mean, obviously, we can change that based on legal advice down the line, but for the time being, I just want to offer that up as a variable that they can work with.
Okay, do I hear a motion then, Commissioner Yao, and if Ms. Sargis might be ready?
I would move that with regard to the direction we're giving to Q2, they do not have to stay with that limit that they set based on the first draft release. In fact, they can go up to the previous defined limit that this commission has set of 1% population deviation in working the retrogression issues.
Yeah. Could I ask for clarification on that? Simply because the previous one was 5% actually, not 1% that you mentioned. We strove for 0%, which is I think why we have these issues of retrogression.
I think the 5% number is history because we have released the first draft already. The 1% is the final number that I believe we set for ourselves, and therefore I'm working with that 1%, which I think is applicable to what we're doing today.
Should we also ask them along those lines that if they were to improve the retrogression, if it's possible to do so, what percent deviation that would result in?
Certainly.
Yeah. Well, I mean, going back, instead of saying this is the maximum, you can go to 1%, what can you do? Or instead saying...
Well, the instruction is that they should advise us to the extent in which they cannot meet the benchmark. So they need to advise us why they cannot do that and to provide it to us in writing.
So I would second that motion, that they can go, just to restate, that in fixing the retrogression issues, as that they can go up to the total of 1% deviation, and as directed by council, if that creates an obstacle in eliminating the retrogression, that they explain so in writing.
Commissioner Malloy.
I do agree with what Commissioner DiGiulio said, and I hear a slight difference in what Commissioner Filkins-Weber said and what Commissioner DiGiulio said. I think it's one thing for Q2 to come back to us and say we couldn't deal with the retrogression issues under the 1% standard and tell us why, versus saying, for example, if at 1.5%, we actually would meet it, and to actually tell us what that threshold is at which they would hit it. And I think given the short time that we're under and even the advice of our VRA council that we heard this morning, the more that we can have multiple options and multiple tracks working, I think that it will help us in the end. For example, if we are to come back next time that we have a business meeting and even consider this thought of, do we change our policy, do we want to consider, it would help if we actually had those thresholds at which we are able to address retrogression already in hand to inform any policy decisions.
Yeah, I'd say what she said is simply that we're looking at our trade-offs, our opportunity costs. If we were to meet retrogression, what is that trade-off? And if they say it's 6%, we would look at that and say, not possible, we probably wouldn't do that. But if this is just having the options so we can make a decision on our trade-offs.
Yes, any other discussion? Seeing none, then I would like a roll call vote. Oh, I'm sorry. Please read the motion back, and then we'll do public comment, and then...
The motion is in regards to giving Q2 the direction for line drawing, that Q2 does not need to stay within the deviation limit set in the first draft maps, but in drawing the second draft maps, Q2 can go up to a total of 1% deviation. No? Restate, please.
Let me see if I can restate the motion in a more concise form. direction given to Q2 is in working the retrogression issue, they do not have to stay with the actuals that they presented in each of the district during draft 1, but they have a latitude of the 1% deviation to work with. And furthermore,
May I try a shorter version of this?
My motion is being accepted very well at this point.
Since there's no second, Commissioner Dye, did you
Okay, I'll let Commissioner Dye make the motion.
Yes. That the instruction be that Q2 has the latitude of up to 1% population deviation in order to improve our ability to not retrogress. And the second part of that would be that they advise us of any threshold beyond that required to meet the benchmark.
Second.
Any discussion? I just have one question because maybe I'm not getting this. The first motion for the first draft maps, Commissioner Dye and Commissioner Giulio, I think you were reading from that potentially, yes, or possibly. What was the motion for the first draft maps previously?
And this is, by the way, Ms. Sarr just had put this shared on a Google Doc, so it might be there as well.
It is. I just don't.
Okay. This is on May 27th in Northridge. It says, in the case of drawing the first draft maps and for drawing the state districts, the Commission shall direct Q2 to strive for districts with a population deviation of 0%. However, when that is not possible due to the constitutional criteria contained in Propositions 11 and 20, the deviation shall not be more than a total of 5%.
Thank you. Any further discussion on the motion? Ms. Sargis, can you read it back, please?
Was there a second to the motion?
Yes.
Yes.
Commissioner Brava.
May I ask what happened to the first motion that had a second?
I withdrew.
He withdrew.
It was withdrawn.
Apologize.
The motion is that Q2 has the latitude to go up to not more than a 1% population deviation to improve the ability to not retrogress, and that further Q2 shall advise the Commission of any threshold beyond that required to meet the benchmark.
Any public comment on the motion?
Hi there. Deborah Howard with the, who am I with? Let's just say the California Institute. I urge you, this is a really bad idea. You have a hierarchy of constitutional priorities. Population deviation is above Voting Rights Act, and Voting Rights Act is above keeping counties, cities, and communities of interest together. You have a really functional 1% deviation that you're operating under right now, and I don't see that making this change actually helps you move farther in the decisions. I don't think it makes it easier for you in making the decisions going forward that you have to make in the next month. So I urge a no vote on this.
Any other public comment? Seeing none, roll call vote, Commissioner Sargis. Or not Commissioner Sargis, I escalated you. Ms. Sargis, sorry.
It's been promoted.
Commissioner Aguirre?
Yes.
Commissioner Anchetta?
No.
Baraba?
Yes.
Blanco?
Commissioner Blanco. The vote.
I'm sorry.
On the motion.
Yes.
Dye?
Yes.
DiGiulio?
Yes.
Wilkins Weber?
No.
Forbes?
No.
Columbus Malloy?
Yes.
Ontai?
Yes.
Parvenu?
Yes.
Raya?
Yes.
Ward?
No.
Yao?
Yes.
10-4, the motion passes.
Thank you. Before we move on with any other discussions, Commissioner Blanco? We could take lunch now and then bring this back up to finish up all of these districts and get into the district on Merced. Do I see any objection to that, or everybody's hungry? Okay. Then we'll go ahead and adjourn this meeting, and I'd like to resume at 1:15. Thank you.